world's screwed up. If it's not COVID, it's something else. It's I don't know where we are in the world. I've got my kids are in Cape Town. Not in Cape Town, in Hout Bay, I suppose that's Cape Town.
Yes, yeah, it's actually wetter than where I live. I'm in the northern suburbs behind the Boerewors curtain.
Okay.
I'm halfway. I'm actually in a part of Cape Town where nobody actually knows where Belleville stops and where Durbanville begins.
Yeah, I've always wondered, is Belleville actually a city or is it just a suburb of Cape Town?
Look, it used to be a city. It used to be a separate municipality, as was Durbanville. But since the metro cities, it's all city of Cape Town now.
Right.
But fortunately, Durbanville still got service points. So things like renewal of car licenses and things like that. I drive up the road into Durbanville and it feels like a town. You know, it's you don't feel like you're part of a big metro because 5 minutes from there you're between the vineyards.
Yeah. So do you have an office or do you work from home as that now?
I've been working from home for the last 10 years. Last
Okay.
8 years. Yeah.
Yeah, I must say, and I find it difficult to go back to the office.
Yeah, the bad thing about working from home is it's actually you have to. It's very easy not to be disciplined and then you keep working for too long.
So I'm very disciplined. I have breakfast, tea in the morning, lunch, then tea in the afternoon, supper, then tea at night. You know, so I'm very cognizant of the time.
Yeah. Yeah, sorry, I just want to, somebody's looking for me. I just want to say I'm in a meeting for the next 3 hours. Okay. I see it's 1 minute before.
Okay, so
yeah, I'm going to open it up, I think, to everyone.
Okay.
That's good.
Let's start.
As people are coming in, so we're getting there.
Mhm. Yeah, I see we've got 52 attendees. 53.
Halfway, over halfway at least.
Mhm.
Should we just give it another 3 minutes?
Danny, Stan, I suppose it's okay if I do a 5-minute break every hour.
I'm sure it's fine, yeah.
Seems to be stuck at 58 now.
It's gone back. 61.
Well, it's 58 people and the three of us.
Okay.
But I think maybe let's do the intro, and I'm sure people
Okay.
will join.
All right. So welcome everybody to the Zoom session. And still in lockdown. Those of you who are working, I'm sure, working from home, etc. The subject that of today's talk is wills and estates. And I don't know if all of you are old enough to remember Dewar McCormack used to be on the radio as a very famous broadcaster back in the day. And he once was doing a radio show, and he said he had walked into his father's office one day and he saw him, or his study, and he saw him packing up bits and pieces and putting in boxes and filing. He said, "Dad, what are you doing?" He says, "Well, I'm packing up everything so that when I go, I've got everything in its place, and you kids will have nothing to worry about. Just go to the file and pull it out." So I'm sure that our speaker, Louis van Vuren, a financial advisor of many years' experience, specializing in the last 20-odd years in fiduciary activities and responsibilities, and you're going to take us through what it means for wills and estates. Those of you who have one, those of you who are specializing in that subject or dealing with clients who need this advice. And so, Louis, welcome everybody else. And Louis, the floor is yours. You need to unmute yourself.
Thank you, Stan. Good afternoon, ladies and gentlemen. For the next 3 hours, I'm going to take you through wills and estates. Just for everybody's comfort's sake, I will every hour do a 5-minute comfort break, and then we'll have to spend some time on the subject matter. It's quite a lot, so it's a question of fasten your seat belts. Now, a good friend of mine and a co-member of FISA, the Fiduciary Institute of Southern Africa, he uses to say that everybody has a will. You either do it yourself or the state will do it for you through the rules of intestate succession. Now, I'm not going to deal with intestate succession this afternoon because I think anybody who does planning on behalf of clients, that's the one situation you want to avoid, is a situation where a client dies without a will. And for every one of us personally, it's the one situation that you just have to avoid. So our agenda today is I'm going to talk about capacity to make a will, the formalities we're going to run through. I'm not going to spend too much time on that. The question, do you do codicils or do you just do a new will? The way out if formalities have not been complied with. Why video wills are not valid in South Africa. This is something that became very topical in the last couple of months, especially during the hard lockdown in the beginning, where there was actually no legal way that you could execute a will without breaking the lockdown regulations. We're going to look at revocation of a will, wills and divorce. There was an interesting court case recently about that. Death, disqualification or renunciation, what happens in those cases? Death obviously of an heir, not of the testator. Interpretation of the provisions in a will, disqualification of heirs, conditional bequest and modus, nude prohibitions, freedom of testation and its limits, and then lastly, I have some pitfalls and practical considerations to keep in mind when we talk about wills. Going to the estates agenda, and I'll run through this later again when we get there. Who can be executors, the reporting of the estate, letters of executorship, finding and taking control of assets, advertising, claims for and against the estate, the L&D account, advertising the L&D, objections against the L&D, taking fees and other administration costs, income tax including CGT, distribution of the estate, and then lastly estate duty. And I think you can use the chat function, the question and answer function, if you, while I'm busy with a topic, if you want to ask something, I will attempt to deal with it as we go along, but there will also be a question session right at the end. Okay, so let's without further ado get into the meat of what we're on about today. The capacity to make a will. I have in most cases given an indication right at the top below the heading of a slide what the applicable legislation for that slide happens to be. Section 4 of the Wills Act of 1953 says once you're over 16 years old, nobody is too young or too old to make a will. So Section 4 says that you have to be 16 to make a will, and everybody who makes a will is presumed in our law to have been in sound and sober senses at the time of making the will. Now I know sometimes I wonder whether, as far as I myself am concerned, whether that's not a stretch, but that's what the law says. And anybody who alleges otherwise must prove it. So if you think that your dear departed granny or anybody else who left you something or didn't leave you something that they should have wasn't in sound and sober senses, it's not just a question of rocking up at the master's office. You have to prove that on a balance of probabilities in a court of law. There is no maximum age for making a will. In some European countries, there is an upper limit over which you cannot make a will. But in our law, there is no maximum age. There's a 2011 Supreme Court of Appeals case of Levine versus Levine, where if I remember correctly, Mrs. Levine was 106 years old when she made a will. Some members of her family didn't like what was in the will, and they contested the will in court. It went all the way to the Supreme Court of Appeals in Bloemfontein, probably at huge cost. And in the end, the Supreme Court of Appeals came to the conclusion that everything pointed towards the testatrix having been in sound and sober senses when she made that will, and the will was declared valid. When the possibility of doubt exists, it's good planning to ensure that evidence is available. There's the 2015 case of Barnard versus the Master, Pretoria High Court case, in which a Mrs. de Mailon wanted to change her will to bequeath the house in which she and one of her sons lived to her other son, and bequeath another property to the son she was living with in the house. This son with whom she was living didn't like that after her death, and tried to prove that she was not in sound and sober senses. But Mrs. de Mailon was actually quite clever. There seems to have been a bit of a history of mental instability, and she went to see a psychologist at the time when she drafted the will, and eventually that piece of evidence and the evidence of the psychologist was in the event a very important piece of evidence, and the court held that the will was her last valid will, and that Mr. de Mailon's claims against the late Mrs. de Mailon that she was not in sound and sober senses was not supported by the evidence available. So from a planning perspective, it's a good idea, if you are aware that there could be an attack after the death of the testator, to preempt that by doing what Mrs. de Mailon did in this case, and that is get some evidence with regard to the state of mind of the testator when the will was drafted. Following people cannot make a will: a person under 16 years of age, persons under curatorship, persons not under curatorship but with clear impairment of their ability to make sensible decisions. The last one is not, they do not suffer automatically from an incapacity to make a will, but it would be inadvisable under such circumstances to have the person make a will without ensuring that there is some evidence that the person was in sound and sober senses at the time of making the will. Formalities. Now, our law is quite clear. The testator must sign each page, and the last page must be signed where the text stops, not at the bottom of the page. So each page of the will, other than the last page, can be signed at the bottom if the page is full of text. The last page, if the text stops in the middle of the page, it better be signed directly below that. There's the Eastern Cape case, 1983 case of Kidwell versus the Master, where the signatures were at the bottom of the last page, and there was about a 15-centimeter gap between the end of the text and the signatures. And the Eastern Cape High Court ruled that the will was not properly signed. The testator must sign in the presence of two competent witnesses, or must acknowledge his signature to them while they are both present. So the testator can sign without the witnesses being present, but then acknowledge his or her signature to the witnesses, which witnesses must be present at the same time and sign in each other's presence. A competent witness, according to section 1, is a person over the age of 14 and who is not incompetent to give evidence in a court of law. The age of 14 is comes from our common law. It actually comes from Roman law. Under the age of 14, everybody was presumed to be incapable of forming intention, and anybody over the age of 14 years was presumed to have been able to form intention. So it is about the ability to go and testify in court, if necessary, that the signature on the will is that of the testator. So just bear that in mind. By the way, witnesses do not have to know what is in the will. They do not have to know what the contents of the will is. All that they must be able to testify about is the fact that it is the testator who signed that document in my presence as a witness. Further, signing a will includes making of initials. It wasn't like that all the time since the enactment of this act. This is an amendment which took effect in 1992. Testator cannot sign or make initials. What now? If the testator is not able to do that, what do you do now? Well, only in the case of the testator, signing includes the making of a mark. So an illiterate person who cannot make a signature can make a mark, sign the will between inverted commas by making a cross on the document where the signature has to be affixed, or putting a thumbprint or something similar on the page. Someone else may sign on behalf of the testator as well. And the question is then, well, when do you use which alternative? It's not a good idea if a person is a quadriplegic to take his thumb and press it on the paper and sign, let the testator sign by making of a mark. I would say that an illiterate person should sign by making a mark, and someone who is too ill or too weak or a quadriplegic or blind should have someone sign on his or her behalf. Now, if someone is signing by making a mark, or someone other than the testator is signing on behalf of the testator, then you have to comply with further requirements, and that is that the person signing on behalf of the testator must sign in the presence of the testator, and the person must sign by the direction of the testator. So the testator has to say, this is my will, please sign on my behalf, or make his intentions or her intentions known in some other tangible way in which or which causes there to be no doubt that the other person is signing in the presence of the testator and on behalf of the testator. Signing by mark or by someone else, or by someone on behalf of the testator, in both those cases, a commissioner of oaths must be present at the signing, and the commissioner of oaths must also sign each page, and the commissioner of oaths must certify on the will the identity of the testator and the fact that the document is the testator's will. Now, if we go quickly to the certificate, this is what such a certificate would look like. It is contained in Schedule 1 to the Wills Act, and it indicates that I, full name or full address, in my capacity as Commissioner of Oaths, certify that I have satisfied myself as to the identity of the testator, full name, and that the accompanying will is the will of the testator. And then the Commissioner must sign, state the capacity, place, and date. So those of you who are certified financial planners, maybe, you are, due to the fact that you're a certified financial planner, you are a Commissioner of Oaths ex officio, and you could be called on to attach such a certificate to a will. So this is what it looks like, and you get it in Section 1 of the Wills Act. Right, so the other important point with regard to signing by making of a mark or signing on behalf of a testator is that the Commissioner of Oaths must attach the certificate to the will as soon as possible after the testator has signed, or the person who signs signed by making a mark, or the person who signed on behalf of the testator signed the will. Now, it obviously may happen that the testator dies before the Commissioner of Oaths attaches the certificate to the will, and that is also catered for in the legislation. The commissioner must, just as soon as possible after death, then attach the certificate. The certificate can be printed or stamped or written on one of the pages of the will, but the Commissioner of Oaths must still sign every other page of the will. He doesn't have to sign again the page on which the certificate appears, but every other page must be signed. Okay, the next point, amendments to a will. Basically, any amendment of a will must comply with all the formalities required for a will. Oh, something slipped my mind. Just before we go further, the other important point with regard to someone signing on behalf of the testator. If it is somebody who is at death's door and is too weak to sign, and somebody else signs on behalf of that testator, I would suggest that you need to have the following people there. Obviously, the testator, the person signing on behalf of the testator, 2 witnesses, the Commissioner of Oaths to affix the certificate. The Commissioner cannot be one of the witnesses. And then in cases where there may be any doubt about the soundness of mind of the testator, I would suggest having a medical practitioner or a member of the nursing staff who had been dealing with the the testator for some time present as well, so that that person can later testify about the state of mind of the testator. Okay. Then amendments must comply with all formalities as required for a will. Therefore, my view is any amendment to a will does not really make sense in the 21st century. With word processors, computers, etc. Rather redo the whole will for the same amount of trouble that you have to take to have an amendment done. Rather redo the whole will. If it's urgent and the testator is fearful that he or she may not survive until the new will is done, yes, then maybe there is a case for an amendment on the original document. But one has to be extremely careful that the amendment does not cause ambiguity and doubt about the intention of the testator. So the wording of an amendment will have to be carefully thought through as if you are drafting a will, a new will. Section 2, sub 2 says that any amendment on a will document is presumed to have been made after the execution of the will. And this is obviously to safeguard against fraud. So any clear amendment or change or alteration on the face of a will is assumed to have been made after the execution of the will. So if you have at the signing of a will, if something needs to be changed urgently there and then the testator and both witnesses, and in the case of a commissioner, must, all the parties who would normally have signed at the bottom of the page and at the end of the will must also sign at the amendment or next to the amendment to show that that amendment was also properly executed. So the question is, a codicil or a new will? Now, codicildictionary.com says it is a noun and it means an additional supplement that explains, modifies, or revokes a will or part of one. As with amendments to wills, my view is steer clear. Don't go there. Don't go the route of doing doing a codicil to a will. Rather redo the whole will. Sorry, there was a bit of a slip here with moving the slide. Yeah, and just to support that point of mine, the use of codicils has dropped sharply over the last 50 years, since the first 50 years ago, the first electric typewriters, and after that, word processors and computers and so on. Right. What happens if a will was drafted but was never properly executed? So it wasn't signed by testator and witnesses as required by Section 2, sub 1 of the Act. Well, there is a way out. Section 2, sub 3 of the Act makes provision for that. And it says, if a court is satisfied, and I've emphasized the words that are important in this subsection. Court is satisfied that a document drafted or executed by a person who has died, in other words, somebody who is now dead, deceased, was intended to be his will. The court shall order the master to accept that document. Now, obviously, there are a number of important points with regard to this provision in the Wills Act. The one is the court has the power to condone. The requirements are there must be a deceased person. That person must have drafted or executed the document with the intention that the document must be his or her last will. But the document falls short of the formal requirements in the sense that if it was drafted by the deceased, maybe the deceased didn't sign, no witnesses signed it. If it was executed by the deceased, in other words, signed by the deceased, no witnesses signed the will, or only one witness signed the will, then the court has to inquire. Firstly, two questions has to be answered. The first is, was this document drafted or executed by the now deceased person? And was it done with the intention that this document must be his or her last will? Once the court is satisfied of these two, once the answer to these two questions is yes in both cases, the court actually has no discretion. The court can then not say, no, it is clear that it was this person's intention. It's clear that this person either drafted or executed the document. The court can then not say, no, we're not going to condone this document. Once those two questions have been answered in the affirmative, the court shall, the Act says, order the master to accept the document as the will of the deceased. The other thing about this is, about Section 2.3, is obviously that to make use of this provision, you have to go to court. And that can be quite expensive. I was involved in especially if it's disputed. I was involved about 18 years ago. I was involved in a case where a family member disputed a will that was drafted and supplied to a testator by the business that I was involved with then. And the allegation was that one of the witnesses was not present at the time when the testator signed the will. The testator executed, signed the will. One of the witnesses was not present. That allegation was made. We did not agree with the allegation. We opposed the claim, and as they say in the classics, we settled on the steps of the court the morning the trial was due to start. And the total legal costs, and it was just in the Free State High Court, it didn't go to the Supreme Court of Appeals. The total legal bills were in excess of 300,000. That's 18 years ago. 300,000 rand. So the moral of the story is, this is something that you need to avoid. We really need to avoid a situation where it's necessary to go to court with an application under Section 2.3, because it can be extremely expensive. So the next point about this is I'm going to go through a couple of cases about what does this mean. The first one is Becker versus Nordea. In this case, the deceased had a will drafted by a trust company on his instructions. The will was in his desk drawer for months without being executed, signed. The court interpreted drafted in 2.3 as personally written or typed and not drafted by another party under instructions from the deceased. So the answer to the first question was no. It was not a document drafted or executed by a now deceased person, and therefore the court did not order the master to accept the document as a will. The particular circumstances of the case were such that there were indications that the deceased was to an extent railroaded into making this will, and maybe on purpose did not sign it. McDonald versus the master is a suicide case where a deceased typed a will on his personal computer at work. He then, in his suicide note, wrote instructions where to find the will and the password to open it. The court, in this case, the Free State High Court, allowed a printout of the document retrieved from his computer as his last will. Van der Merwe was the master of the High Court and another. A and B agreed to benefit each other in their wills. A executed the will properly. B drafted the will in an email, which he sent to A. B died without ever properly executing the will contained in the email. In this case, the court accepted a printout of the email as B's will. The court answered the two questions in the affirmative, said yes, this was clearly drafted by the deceased, and it is clear from the wording of the will and from the email, the context of the email, that it was his intention that this document should be his will. Obviously, the fact that B himself typed the email, was taken as a very important indication of his intention. Van Vetten and another versus Bosch. Those who are old enough to remember the 1992 Cricket World Cup may remember a South African pace bowler called Tertius Bosch. And this case was about his will, or the document that he drafted, which eventually was accepted by the court. Court answered the two questions in the affirmative. And in this case, what makes it important is that the court took the wording the deceased used, as well as his instructions to his friend, into consideration in deducing that it was his intention that the document was to be his last will. The situation was that the deceased was estranged from his wife, or their marriage was under strain, and he basically wrote the letter and the will to his friend, and the circumstances and the deceased's actions were taken into consideration by the court as an indication of his intention. There was never any doubt that he drafted the documents himself. Smith versus Parsons, another suicide case. In this case, the deceased left, again, a suicide note on a kitchen top in his house. He put the document below, underneath his Bible with a crucifix on top. The court regarded that as a strong indication of the sincerity that he regarded this document and the importance of the document. It was an interesting case for another reason, and that is that he didn't deal with all his assets in this suicide note. There was a pre-existing will in which his ex-wife inherited some assets. The Supreme Court of Appeals, after the Durban High Court initially did not order the master to accept the document as a will, the Supreme Court of Appeals overturned that decision and ruled that the note bequeathing certain things to his girlfriend must be read in conjunction with his last validly executed will. That in itself is not unusual, that that two will documents be read together. That has happened in a number of other cases. Then, in just over a year ago, there's the Western Cape High Court unreported case, Dryden versus Harrison. In this case, the deceased started an email to his girlfriend with the words, "This serves as my final will and testament." And despite that, the court found that it was not sufficient indication of his intention, that the email itself must serve as his will. The court found that it was an indication of what he wanted to write in his will, but that particular email was not intended to be his will. Now, the court's reasoning appears to be flawed. I'm pretty certain that it was an incorrect decision, as there was no evidence that he intended to follow the email up with a formal document. It looks as if he always intended the email to be his will. Okay, so now the question, why a video recording on your smartphone cannot be a valid will in South Africa. Firstly, the Wills Act does not define the word document anywhere. That means we have to go to the dictionary. And in a dictionary, you will find the explanation of the word document mostly refers to a hard copy, to a printed or a written piece of paper. Now, these days, we talk about a document as an electronic file as well, but there's a further indication that electronic documents cannot, without an application under Section 2.3, be accepted as a will, because the Act requires each page to be signed by the testator. So that is not going to be that easy with an electronic document. Yes, you can sign a PDF document electronically, but the witnesses must sign in the presence of a testator and each other. So that is not always going to be the case. And if that is the case, then the question is, why don't you just do a paper document? Why then go the route of a video recording on your smartphone? And then the killer is that wills are specifically excluded from the Electronic Communications and Transactions Act, which in Section 12 says that any requirement in any law that a document must be in writing is satisfied if that document is in the form of a data message. But in the schedule to this will, the wills are one of 4 types of document that are excluded from the operation of this act. The other 3 are bills of exchange, in other words, a check, which we hardly ever see anymore. And the other 2 are long-term leases for of immovable property, and the sale of immovable property, which needs to be in hard copy and cannot be in electronic format. So, in short, a will has to be a hard copy document, which is capable of being signed. The question the world over in the COVID-19 pandemic was, well, what do we do now? And some countries actually came up with temporary measures. New Zealand, Canada, some of the individual states in the United States of America came up with emergency regulations allowing the electronic signing of wills and the signing of wills in counterpart format, where the testator and the witnesses are not in the same location when the document is signed. In New Zealand and in Canada, that was done under their emergency legislation, where the government had the power, the executive arm of government had the power to do that. In South Africa, the Disaster Management Act that was used, or still used, to promulgate the regulations ruling the lockdown, does not make provision for that. Does not make provision for relaxing the requirements of any legislation. So we couldn't have that. Submissions were made to the Department of Justice to declare the signing of wills an essential service, but that we never got a response on the submission that was made. Revocation of a will can be revoked in the following ways: by a revocation clause in a later validly executed will, by the testator physically destroying the document. In our common law, there is a presumption that if a will, original will that was known to be in the possession of the testator, later cannot be found, the presumption says that it is presumed that the testator destroyed it with the intention to revoke it. So there is a presumption of intention to revoke a document if it cannot be found and was probably destroyed. Obviously, the testator can physically tear up his will, and if it's the only original, there can be copy originals. The Administration of Estates Act make provision for the master accepting a copy original, not a photocopy, a copy original. In other words, a second document that was properly executed, that runs or that reads exactly the same as the other copy original. The court can also declare a will revoked under Section 2 capital A of the Wills Act. Now, on a practical level, be very careful of revocation clauses in a will, because it could have unintended consequences. The Wills Act does not require a will to be dated, but it's good to do that for this very reason. It's actually quite strange that there is no requirement in the Wills Act that the will document must be dated. But practically, it is the only way to determine which of several will documents was executed last. Because if validly executed, that document, if it has a revocation clause, will have revoked all previous documents. In fact, whether it has a revocation clause or not, it will revoke previous wills in total if it deals with all the assets in the estate of the deceased. By the way, that's another reason why you should have in every will a bequest of the residue. Whatever is left after all the creditors have been paid and after all the special bequests, the legacies have been paid out or transferred, there has to be a catch-all bequest of the residue. Otherwise, you could end up in a situation where you have to read two wills in conjunction if the later will does not deal with the residue of the estate. Be careful with the wording of a revocation clause. What is the intention? What do you want to revoke? What does the clause revoke? So let's have a look at some examples. First one, I, John Doe, married out of community of property with the inclusion of the accrual to Julia Doe, born Smith, hereinafter called my spouse, hereby revoke all previous wills, codicils, and any other testamentary writings and declare this document to be my last will and testament. Pretty clear. So this one revokes all previous wills. Well, a deceased estate that I was involved in 15, 16 years ago, the deceased came to South Africa as a young man, made a fortune here. It was quite a substantial estate. Had a South African will, which had a clause like this. What the deceased didn't tell the person who drafted this will for him was that he had inherited assets in his country of origin. And that those assets were dealt with under a will in that country. So this kind of revocation clause revokes all previous wills. And the authorities in that country, when they saw the South African will, said, well, our will is now revoked. So there is no valid will here. And then obviously the rules of intestate succession had to be followed in that country with regard to that to those assets which were not dealt with under his South African will, and for various reasons could not be dealt with under his South African will. So you could have something like this. I, John Doe, married out of community of property with the inclusion of the accrual to Julia Doe, born Smith, hereinafter called my spouse, hereby revoke all previous wills, codicils, and any other testamentary writings dealing with my South African estate, and declare this document to be my last will and testament with regard to my South African estate only. That obviously brings up the planning question, whether one should have separate wills for South African and overseas assets. And that will depend to a large extent on two things. One is the nature of the assets. And the second is what does the law of the other country say? Now, there is a European Union set of rules with regard to law of succession, which applies in the European Union now, and that allows for property to be dealt with in any of those countries, to be dealt with according to the law of the country of which the testator was a citizen. So as a testator, you can elect to which legal system must apply to your will. But to come back to the nature of the assets, let's say a bank account in the UK can practically effectively be dealt with by a South African executor without too many problems. The moment you start dealing with immovable property in another country, it's a whole different ballgame. Some countries have forced heirship rules where a certain portion of the estate in that country has to go to the surviving spouse or to the children, and there are all kinds of other complications, and mostly you will not be allowed to deal with immovable property as a South African executor under a South African will without jumping through a whole number of hoops. In a case like that, it would probably be better to have a will in that, a separate will in that jurisdiction. So yeah, make sure your revocation clause actually achieves what it should achieve. Okay, revocation of a will. The court must declare a will revoked under Section 2 capital A if it is satisfied that the testator with the intention to revoke made or caused to be made a written indication on his will, or performed or caused to be performed any other act with regard to his will which is apparent from the face of the will before his death drafted another document or caused such document to be drafted, which makes it which gives an indication that his will is revoked. So practically speaking, writing cancelled on a will document will be a written indication, as indicated in the first of these bullet points. Drawing lines diagonally across the page will be another act, and then before his death drafted another document or caused such document to be drafted is so wide that it could include a document which does not qualify as a valid will, but which was ordered to be a valid will by the court under Section 2 sub 3, and even a document which does not pass muster under Section 2.3 may conceivably be sufficient grounds for the court to declare a previous will revoked under Section 2 capital A of the Wills Act. Drafting a new will which is not executed at the time of death, that's the question. I think it will it may be taken as an indication depending on the circumstances. Wills and divorce, quite an interesting one. Section 2B says that if any person dies within 3 months after his marriage was dissolved by divorce or annulment, and that person executed the will before the date of such dissolution, that will shall be implemented in the same manner as it would have been implemented if his previous spouse had died before the date of the dissolution concerned, unless it appears from the will that the testator intended to benefit his previous spouse, notwithstanding the dissolution of the marriage. So basically, there's a 3-month window that you have after divorce to change your will. During that time, your ex-spouse will not inherit anything that was bequeathed to the spouse. Obviously, if the spouse dies after the expiry of the 3 months, it will result in anything bequeathed in the will to the ex-spouse to go to the ex-spouse. And obviously, the wording of the will is going to be important to determine whether what the intention of the will, the pre-divorce will happen to be. Okay, so a bequest to my spouse, where the testator married again, will result in an interesting situation, obviously, because now the question is, well, didn't the testator leave everything as is because the will just referred to my spouse? There could be an argument that the intention at the time of drafting the will was the spouse, the now divorced spouse. Nothing like this has ever come before the courts, and it would be interesting to see what a court would make of that. A very interesting recent case, J.W. versus Williams Ashman, N.O. nomine offici, and others. For those of you who don't know, that N.O. just indicates that Williams Ashman did not appear in his or her own capacity in court, but in the capacity on behalf of, and in this case, on behalf of the deceased estate. Williams Ashman was the executor in this case. In this case, J and N were married for 5 years when N died on 8 December 2016. She executed the will 4 days before their marriage, in which she bequeathed the full residue to my husband. The marriage ended in divorce on 24 October 2016. N died on 8 December 2016 within the 3-month period, and Section 2B applied, and J could not inherit. J wasn't happy with that and attacked Section 2B in court on the basis that it was contrary to Section 25 of the Constitution, the property clause in the Constitution, and secondly, that it took away his rights to legal redress under Section 34. The argument under Section 25 was that it interfered with an individual's freedom to dispose of his or her property as she or he sees fit. Now, I'm sure most of you will agree with me that that was quite a long shot. The court rejected both arguments because the court said the right of disposal over property is never absolute, and the proportionality of the provision was perfectly in line with the outcome that it intended to achieve, and that is to give divorcees that little bit of breathing space to get their affairs in order. The court took it as granted that most divorcees would not wish to benefit each other after the divorce. And the Section 34 argument, the court said, that's not a good argument because it does not take away your right to approach the court with evidence that from the will that the deceased still intended to benefit you. So Jay was not successful there. I think we need to take our 5-minute comfort break before I move on to the next topic. I see it is 14:01 now.
Do you want to come back at 10 past or 5 past?
Let's make it 10 past. It's fine. We're doing well. We're quite on schedule as I planned it. So yeah, let's be back at 10 past.
Let me also just mention while you there was a question from the one in the chat about with writing cancelled on a will, saying that surely anyone can write that, if I get that correctly.
Yes, obviously, obviously it will be a case for evidence, because Section 2 capital A once again requires a court application. You have to go to court to get the will declared revoked by the court. So any case like that would be a civil matter, and the burden of proof in civil matters is on a balance of probabilities. So you will have to have some indication or some evidence that can push the application over that threshold of, on a balance of probabilities, this was the deceased who did that. Okay, all right, let's be back at 10 past. Sorry, Danny, I don't see the questions. I've got question and answer open on my side, but I didn't see any questions.
It was asked in the chat group.
Oh, right. Okay.
Yeah.
Okay. I've got that. Right. Okay. Thanks. All right. We'll start at 10 past 2 sharp. Right, I see it is 10 past, so let's carry on. Still some work to get through. The next topic is death, disqualification, or renunciation of an inheritance. Death is the prior death of an heir or legatee under a will. Disqualification and or renunciation of an inheritance. That is ruled by section. That is ruled by section 2C of the Wills Act. So let's just have a look at what that reads like. It says surviving spouse and descendants of certain persons entitled to benefits in terms of will. If any descendants, 2C1 says, if any descendants of a testator, excluding a minor or a mentally ill descendant, who together with the surviving spouse of the testator is entitled to a benefit in terms of a will, renounces his right to receive such benefit shall vest in the surviving spouse. 2C2 says, if a descendant of the testator, whether as a member of a class or otherwise, would have been entitled to a benefit in terms of the provisions of a will if he had been alive at the time of death of the testator, or had not been disqualified from inheriting, or had not after the testator's death renounced his right to receive such a benefit, the descendants of that descendant shall, subject to the provisions of subsection 1, per stirpes be entitled to the benefit unless the context of the will otherwise indicates. So section 2C1 is only applicable to renunciation of a benefit under a will, not to disqualification or prior death. 2C1 cannot be excluded from a will by a clause expressing a different intention. As you've seen, section 2C2 says specifically that it will apply unless a different intention is clear from the will. 2C1 has no such wording, and therefore it always applies. So the question is, does it mean that the descendant and the spouse must share the same benefit, want to apply, or must both of them just be entitled to any benefit under the will? And this is a question to which there is no answer. There is no clarity about this, and there's no court case about this specifically. And there has been some academic writing about this, but we have absolutely no clarity about this. In fact, I wrote an opinion last week for an executor who asked the question in particular circumstances. In those circumstances, the deceased bequeathed immovable property, contents of a house and cars to his spouse. He then bequeathed some investments, listed shares and collective investment scheme units and so on to his two daughters, and bequeathed the residue to the spouse. And the question I was asked is, if the two daughters renounce, because the value of what they stood to inherit was quite substantial and would create an estate duty problem, and they felt that their mother should rather have this, if they renounced, would section 2C1 apply? My answer was, I don't know and nobody knows. Because both arguments have merit. If you look at the Interstate Succession Act, there's a similar provision there, section 1 sub 6 of the Interstate Succession Act, and that says that if the spouse and descendants are jointly entitled to a benefit in terms of the rules of interstate succession, and one of the descendants renounce, that portion will accrue to the surviving spouse. The counter argument is it's a totally different situation. In a will, the deceased person, the testator, exercised his freedom of testation to bequeath certain things to certain people. The only case that is particularly about this section of the Wills Act is the case that I show there, Musa and others versus Haneker and others, 2017 Western Cape High Court case. But there, the two Muslim spouses and all 9 children from both these marriages. The one was a civil marriage. The one was a marriage just under Muslim rights. All 9 children agreed that they would like to renounce their inheritance so that the 2 spouses can get everything. But there, all of them, the 9 children and the 2 spouses, would have been entitled to the same inheritance, the residue of the estate, because the residue of the estate was to be divided according to the Sharia rules. So the case does not really tell us anything about this question. Therefore, I think from a planning perspective, one needs to be careful not and point out if there is any doubt whether a descendant will or there's chance that a descendant may renounce, that there may be another way of dealing with it. You can obviously imagine that in what we quaintly call in South Africa reconstituted families, it could be quite a mess if a child of the deceased, who is not a child of the surviving spouse, renounces, and that portion accrues to the surviving spouse. The other important point about this is if such a descendant has descendants, then Section 2C2 should apply. And to then renounce and let this accrue to the surviving spouse, you cannot renounce on behalf of a minor child. So then you stand the chance, if the narrow interpretation of this provision is accepted, then you stand the chance that that benefit will end up with the descendant of the renouncing descendant, and not with the surviving spouse. So it may actually thwart the whole purpose of the exercise. Section 2C2, we just read, says that a descendant who renounces or who dies before the testator or who is disqualified will be represented by his or her descendants. In other words, the grandchildren of the or the great-grandchildren of the testator, depending on who the first descendant was that stood to inherit. That wasn't always the case. The common law didn't work like that, but in 1952 there was a General Law Amendment Act which basically created this representation by descendants of a descendant, but it did not include renunciation and disqualification. So 2C2 just put that right. Now, as I said, 2C2 can be excluded from the will by a clause expressing a different intention. And it's applicable only in the case of descendants of the testator. So it means that the default option in all 3 cases, that's renunciation, disqualification, or prior death, the descendants of the descendant will represent such a predeceased, disqualified, or renouncing descendant. In the case of other heirs, the jus accrescendi or joinder will apply. And we're quickly going to run through that. There are, in our common law, 3 kinds of joinder before I go there, I see there's a question. Can a scanned copy of a will with signatures be construed as a will in the absence of the original, for example, the original lost by the master or just lost? Yes, it can, but only the court can order that. The master cannot accept a copy other than a copy original. The Administration of Estates Act makes specific provision for the acceptance of a copy original, but a photocopy, a scanned copy, cannot be accepted without a court order. The Administration of Estates Act does not give the master the authority to accept that. So the only institution that can order that is the court, is the High Court. All right, so let's carry on with the joinders. There's something that's called joinder re et verbis. That's the same asset is bequeathed to more than one person in the same clause in the will. If the one cannot inherit, the benefit accrues to the other or to the others. So to bring that into connection with section 2C2 is if the class of beneficiaries under the will are not descendants of the testator, but let's say, for instance, a portion of the residue is left to my brothers, then unless the will stipulates that there will be representation by the descendants of the members of that class, joinder re et verbis will apply, and if one cannot inherit, the benefit will accrue to the others. So in planning and in will drafting, it's extremely important to understand what you want to achieve, because of these common law rules that are lurking in the background. Joinder re tantum is the same assets bequeathed to more than one person in different clauses of the will, and there the same applies. If one cannot inherit, the benefit will accrue to the other or to the others, other members of that class. And then there's joinder verbis tantum, which is the same assets bequeathed to more than one person in the same clause in specific proportions. And there, if the one cannot inherit, that portion goes to use or intestate heirs, because the common law argument there is that the person who cannot inherit, for whatever reason, that benefit, because it was allocated in specific proportions in the will, that proportion vests in that branch of the family and must go to the descendants of or whoever his intestate is, his or her intestate heirs must be. So important to understand that 2C2 only applies to descendants of the testator. Any other class of heirs will fall under one of these three joinders, depending on the terms of the will, and therefore it is extremely important to accurately word the provision in the will. Okay, death, disqualification or renunciation, continued. I basically dealt with this, but ensure that the testator understands what she or he wants to achieve with a shared bequest. Ensure that the testator understands the consequences. Be careful with wording. Bequeathing to my brothers has different consequences, as I explained. And the effect, if the effect of the use of crescendi is to be avoided, the wording has to reflect accurately what the testator wants to achieve. Right, so interpretation. In common law, the golden rule of interpretation of a will is comes from a 1914 appellate appeal court case, appellate division at that stage, appellate division of the High Court, Robertson versus Robertson's executors, and it says the golden rule for interpretation of testaments is to ascertain the wishes of the testator from the language used. And when these wishes are ascertained, the court is bound to give effect to them unless we are prevented by some rule of law from doing so. So that means the ordinary meaning of the words used seen in the context of the document will determine what interpretation will be attached to the words used. In our law, armchair evidence is allowed. In other words, the court can go and sit, so to speak, in the testator's armchair and see the world from the testator's perspective. Can try to put itself in the shoes of the testator in order to interpret what the testator intended in the will by the use of the words. Extrinsic evidence, that is evidence from outside the document, is only allowed in limited circumstances, and the two well-known exceptions where extrinsic evidence is allowed is one where technical terminology is used. The court can call, or any party can call witnesses, but the court can accept evidence as to what these technical terms mean. And the second one is the court can take evidence into consideration whenever there is ambiguity, or a word could mean more than one thing. And so evidence about what a person in the testator's position would mean by such a word can be accepted. But other than that, extrinsic evidence from outside the document is not acceptable. There are some statutory rules of interpretation that are also written into the Wills Act, Section 2D. And that is, adopted children are regarded as the natural children of the adoptive parents. Since 1992, all ties between adopted children and their natural parents are severed upon adoption. And the adopted children are regarded as the natural children of the adoptive parents. So any bequest in a will to my children will then include adopted children. No more illegitimate children in our law of succession since 1992. Previously, under common law, a child born out of wedlock could inherit from his or her mother and vice versa, but could not inherit from his or her father, natural father, and vice versa. The father could also not inherit from such a child. That is gone. A child born out of wedlock is now, since 1992, in all respects the equal of a child born in a marriage. Any benefit to children or to any other class of persons will vest in all the members of that class who are alive at the time of death of the testator, or who are already conceived and born later. So if the child is not if the child is not born alive, then the heirs of that child will not stand to inherit. If the child is born alive, even if it's only for a number of minutes, then obviously the intestate heirs of such a child could stand to inherit, because that child could be a member of the class. Obviously, it will take medical evidence to determine whether the child could have been conceived before the death of the testator, but that's a matter for evidence. The legal position is any child who's been conceived and born alive later will form part of that class of heirs. I see I've got two questions. Okay, I've answered that one. Can a child who's adopted inherit from their adoptive parent and their natural parent? No. All ties with the natural parents are cut upon adoption. Obviously, formal adoption, not foster care or something like that, but formal adoption, all ties between that child and the natural parents are cut, and the child is regarded only as the child of the adoptive parents. All right. Disqualification of heirs, that's an interesting one. Any person and his or her spouse who signs as a witness or signs on behalf of the testator or writes any part of a will in his or her own hand is disqualified from receiving any benefit under that will. This will not apply if the court orders that the person may inherit if it is satisfied that that person did not defraud or unduly influence the testator. There was a case a number of years ago, Brown versus Blom, where I think it was the second spouse of the deceased helped him to draft his will just before he went on a business trip, and he actually asked her to help him. And there was evidence about that. The deceased then went on his business trip and died while he was on the business trip, and his children from a previous marriage did not want the surviving spouse to inherit under that will, and they then pointed out to the master that she wrote the will in her own hand. The master then obviously could not accept the will, she was then disqualified under the will, and she went to court, and the court ruled that everything pointed to the fact that there was no undue influence, that there was no fraud, and the court declared the surviving spouse not to be disqualified from inheriting. It will also not apply to a benefit that is not more than what the person would have inherited under intestate succession. If the bequeathed benefit is more, it will be limited to what the person would have inherited under intestate succession. Being nominated as executor, trustee, or guardian is regarded as a benefit. So it is regarded as a benefit if you are just nominated as guardian of the minor children of the testator, and therefore you are disqualified from that as well if you sign as a witness or you sign the will on behalf of and under instruction of the testator, or you write any part of the will in your own hand. Another case that I was involved in indirectly a number of years ago is I forget the name of the case now, but in that instance, the third husband of the deceased went to the newsagent, bought a will template, brought it back, and eventually discussed it with the deceased. She was terminally ill. He eventually couldn't get her to sign it, and afterwards came to court to get it accepted under Section 2(3) of the Wills Act. Obviously, that application did not succeed. I see there's a question: is probate always required to close a bank account in the UK? And if so, does it take away South African executors' right of control and administration of funds in SA? I'll rather deal with that when we get to the the estates part. There's another question. So if you're nominated as executor, you cannot be a beneficiary of an estate. No, that's not what it says. It says if you sign as a witness, or you sign on behalf of the testator, or you write any part of the will in your own hand, then you are disqualified from receiving any benefit under the will. So if you sign as a witness, or you sign on behalf of the testator, or you write any part of the will in your own hand, you cannot be the executor the estate, and you cannot be the trustee of any trust created in that will, and you cannot be a guardian of the minor children of the testator. So it's not that an executor cannot be a beneficiary. That happens every day. Many times the surviving spouse is the executor and is the heir of the bulk of the estate. So no, that's not what it means. Danny, I see somebody says, Andrew says, I'm losing connection on and off for the past 4 minutes, so I don't know whether you can do anything from your side. Let's carry on. Okay, we've gone through this. I don't know why this came up again. Two kinds of conditions, conditional bequests. Two kinds of conditions. There are suspensive conditions, and a suspensive condition suspends the bequest until the fulfillment of the condition. So, for instance, I bequeath 1 million rand to my son James, which amount will vest in him when he achieves his LLB degree. This is obviously not very practical if the uncertain future event until when the bequest is suspended is likely to not happen in the next year or two, because the estate will have to be kept open to be able to pay the legacy. And obviously, if the son does not achieve the degree, then the legacy will fail, and that 1 million rand in the example will fall into the residue of the estate. Resolutive conditions is the bequest lapses when an uncertain future event happens. For example, I bequeath my house to my spouse until she or he remarries. That is a resolutive condition. And now, conditional bequests can be lawful or unlawful. Unlawful conditions would be illegal conditions where the heir is required to do something illegal. Amoral conditions where, for example, where a child is expected to divorce to qualify for a bequest. I bequeath my house in Somerset West to my daughter on condition that she divorces that good-for-nothing husband of hers. That would be an amoral condition. Conditions which are contrary to any provision of the Bill of Rights. Very prevalent in the last 20 years were court cases where conditions that only people of a certain race group or only people of a certain gender be benefited were ruled unconstitutional by the courts because they were breaching Section 9 of the Constitution. Linked to conditional bequests is the so-called nude prohibitions, or the Latin term nudum praeceptum. That is a resolutive condition without an alternative bequest if the condition arises. For example, I bequeath my house to my spouse until she remarries. If it stands like that, it's actually a nude prohibition, because what happens if she does remarry? Okay, I have a question. How would an executor deal with the assets relating to unlawful conditional bequests? Would that asset form part of the residue as well? That will obviously depend on whether there is an alternative bequest or not. If not, yes, then it will fall into the residue. If there was an alternative bequest, obviously that will then become active. All right. Yeah, I need to say something just quickly about modus. It is in the heading, but I eventually dropped it out of the presentation. A modus is a bequest that is subject to a duty placed on the heir. And a good example of a modus is the so-called bequest price. I bequeath my farm to my son on condition that he pays R1 million to my daughter, for instance. There, it is not a condition. It is a bequest subject to an obligation, and the obligation must be fulfilled in order to, or arrangements must be made for it to be fulfilled in order for the bequest to go to the legatee. The bequest cannot be accepted without the obligation, and that's the difference between a modus and a conditional bequest.
Before we carry on, there was also one message in the comments chat section, a question. If you're nominated as an executive, you cannot be a beneficiary of estate. Is that correct?
Yeah, I actually answered that one.
Sorry, I missed it.
Okay. All right. Freedom of testation and its limits. South Africa has a very high level of freedom of testation. We don't have any forced heirship rules. In Mauritius, for instance, if you have a spouse only and no children, the spouse must get 50% of your estate. If you have, for each child has to get 25% of the estate. If you have only children, up to 3 children. After that, the children will all share that 75% of the estate. There are similar rules in places like France and Spain and so on. But South Africa, we don't have that. But there are limitations on freedom of testation. Provisions that are contra bonus mores, or against the good morals of society. Constitutional limitations. There's the BOE trust case in which I was personally involved. We actually decided to appeal the Cape High Court decision. It was a case where a trust was created, a testamentary trust was created in a will, and the trust was to supply bursaries to postgraduate study in organic chemistry at European or American universities, with a condition that the bursar had to come back to South Africa after graduating overseas. And there was a further requirement that it was limited to white students. We went to court because we couldn't execute that part of the will, or the trust could not operate because the universities that were supposed to take part in this said, well, we cannot do this obviously because it flies in the face of Section 9 of the Constitution. The Cape High Court said, well, I'm not sure that this is unfair discrimination, because all indications are that the testatrix wanted to stop the brain drain from South Africa and actually wanted these people to go get a very scarce skill overseas and then come back to South Africa. It went to the Supreme Court of Appeals. The Supreme Court of Appeals said, look, this is the guy's freedom of testation. And if the trust cannot operate, there are alternative bequests in the will. No, we are not going to scratch the word white from the will. So that was an interesting one. Maintenance obligations towards minor children are obviously also a limitation. The Maintenance of Surviving Spouses Act is a limitation on your freedom of testation, because you cannot disinherit your surviving spouse completely if the surviving spouse is going to be without care and without means to survive. because there is a potential claim under the Maintenance of Surviving Spouses Act. There's the accrual system, which effectively limits your freedom of testation. Obviously, there it is you yourself who limited your freedom of testation by getting married under the accrual system. But nevertheless, it is a limitation. There are limitations on fideicommissions. There's the act that limits a fideicommission to 3 generations. And there's the Subdivision of Agricultural Land Act, which prevents any agricultural land from being subdivided without the approval of the Minister of Agriculture. All right. Then pitfalls and practical considerations. There are quite a number. Inaccurate wording. We've spoken about that already. I see there's a question about writing in own hand. I'll get back to that as soon as we're done with the slides on wills. Inaccurate wording. All you have as that golden rule in Robertson versus Robertson's Executors states is you have the words in the will. That's all that whoever has to interpret the will has. So those words better be accurate. So what do we see in wills? Cash, money. Does cash only include the cash in your wallet, or does it include the money in your bank account? Does money include other investments? What about Krugerrands? Things like that. It's best to accurately describe what the object of the bequest should be. My business, what on earth is that? Is it a sole proprietorship? And there's an interesting case, you can go and read it. It's about a helicopter that crashed here in Cape Town. Some overseas visitors were slightly injured, and they sued the owner of Sports Helicopters for their medical costs and pain and suffering, etc., etc. And then the owner of Sports Helicopters died. And the question was, this was a sole proprietorship, so what happens to that claim now? And the Cape High Court said, well, that claim died with him because he was a sole proprietor and he was the negligent party. There was no other business that could be sued, and because it was a personal claim against him, and the claim was of a personal nature for pain and suffering and etc. The claim died with him. Partnership, close corporation or company, there's only an interest or shares in that to bequeath. So be careful not to talk about I bequeath my business and then it's a company and the person only owns 80% of the shares. All that you can bequeath is the 80% of the shares that he owns. Buy and sell agreements, we don't have time to go into depth with regard to buy and sell agreements, but a buy and sell agreement basically is an agreement where a business interest is converted into cash upon the death of the person holding the business interest. And that is usually funded with life insurance, and the life insurance pays out, and the person who receives the payout, who is the partner or co-shareholder of the deceased, then uses that money to buy the business interest from the estate. It's to the benefit of the estate because that business interest is converted into cash immediately, and it's to the benefit of the business because there is no surviving spouse or minor child who now becomes a shareholder or an interest holder in the business. Pitfalls and practical considerations continued. Registered in my name or in my possession. What does that mean? Personal effects. What does that include or exclude? Collections, coins, stamps, etc. Is that part of personal effects? It could be quite valuable. about probably almost about 20 years ago, the business that I was involved in then administered a deceased estate, and there was, in the inventory of the estate, there was a costume jewelry to the value of about 5,000 rand. The daughters of the deceased started arguing about who gets what out of this 5,000 rand costume jewelry. The executor eventually said, okay, bring me the stuff. I don't know what it looks like, but bring me the stuff. I'll have it valued, and then we can divide it equally according to value. Needless to say, when the costume jewelry turned out to be quite valuable, the jeweler who valued it said to the executor, I'm not going to allow you to leave my shop with the jewelry without a security guard. So please arrange a security guard. I'm not going to allow you to leave here the safety of my shop without protection with that with you. It turned out the jewelry was worth almost 400,000 rand. It pushed the estate into estate duty, and the daughters had to pay cash into the estate to pay the estate duty. The contents of my workshop. What does that mean? My garage, does that include the vintage Rolls Royce that happened to be parked there? Be accurate with wording. Bequests in trust is the bequest to the heir legatee or to the trustees. It makes a huge difference. A bequest to the heir of the beneficiary creates a bevint with consequences when the heir reaches age of majority, because in a bevint, trust property belongs to the beneficiary and is placed under control of the trustee. If you create an ownership trust by bequeathing it to the trustees own the trust property, and there is much more flexibility. The wording of the bequest is obviously of the utmost importance to determine what type of trust is created. I've seen many wills where no matter how many times you read it, you still don't know whether the intention was to create a bevint or an ownership trust. And that is that with regard to the wills. So let me quickly deal with the question about writing. The question is writing in own hand the same as typing up a will on instruction of the testator who requests you to draft a will on his or her behalf? The answer is no, because the act specifically refers to writing in your own hand. I'm not going to go back there now, but in the slides that you received, section 4A is there. You can go and read the wording, and it actually refers to writes any part of the will in his own hand. So no, it does not include the typist who typed the will. Okay, I see we still have some time before we take our next break. So let's see, it looks like there's another question here. It asks, what is the risk of a joint will? Personally, I don't like joint wills at all, because after the death of the first dying, the survivor is not bound to that joint will any longer and can basically make a new will. While the joint will is in existence, the parties are not bound to that joint will before death. Each one of them can go out and make a will without even telling the other party. So personally, I don't like a joint will. If you want to decide together, two spouses want to decide together what they're going to do, it's as easy and it's actually even easier to do two mirror image wills, or to do two wills, one for each party. And in the case of marriage in community of property, you can make them mirror image wills so that the same effect will result in both cases for the same amount of trouble than doing a joint will. So personally, I'm not keen on joint wills. Okay, let's go with estates. I'm going to look at who can be executors, reporting of the estate, letters of executorship, finding and taking control of assets, advertising, claims for and against the estate, the L&D, advertising the L&D, objections against the L&D, taking fees and other admin costs, income tax, including CGT, distribution of the estate, and estate duty. Now, I've received 2 questions before yesterday or so. I will deal with them when we get to the specific portions of this agenda. Okay, so who can be an executor? Well, firstly, we had an archaic piece of legislation. I say had, and you will see or will hear soon why I say had. We had an archaic piece of legislation called Regulation 910. And this was promulgated under the Attorneys, Notaries and Conveyances Admission Act of 1934. And it was perpetuated by sections 86 and 81 of the Attorneys Act 53 of 79. But section 119 of the Legal Practice Act, which perpetuates certain regulations and actions that were taken under the Attorneys Act of 1979, is not wide enough to save regulation 910. So in my view, it doesn't exist anymore, but some master's officers sporadically demand compliance with this. The purpose of this regulation was to regulate who, apart from attorneys, may administer deceased estates. Now, it has a bit of a history. In the 1830s, two boards of executors started in Cape Town. The first was in 1834. It was called the South African Association for the Administration and Settlement of Estates. That was formed in 1834. It still exists. About 9 years ago, I was still a director of South African Association. The second one was 1838, the Board of Executors, the old BOE, which is now, both of those companies are now part of Nedbank. But that started the trust company movement in the world. In fact, South African Association is the oldest trust company in the world. And in the 1960s, the attorneys profession were getting perturbed by the boards of executors and trust companies taking more and more and more of market share. And in 1967, they started agitating with the then Minister of Justice, and Regulation 910 was promulgated on the 22nd of May 1968, I think. So what did this say? Regulation 910, paragraph 1, defines what trust companies and boards of executors are, and those were the companies which were in business as such on 27 October 1967. So what it intended to do was to lock down the number of businesses that could operate in this area, that could administer estates and trusts and so on. Although it didn't do anything about trusts, it purely dealt with estates. Paragraph 2 states that only attorneys may administer estates. Paragraph 3 then permanently exempts the following from the operation of paragraph 2: boards of executors and trust companies, public accountants registered under the old Act of 1951. It's a open question. Who are the successors to those public accountants? Some people say SAICA, some people say no, IRBA, the Independent Regulatory Board for Auditors. Then there was also a category of brokers licensed as such on 27 October 1967, although I don't think there are many of them left. And then paragraph 4 partially exempts natural persons nominated in the will, employees of attorneys, banks, employees of trade unions. Can you believe it? Etc. So the natural persons nominated in the will is obviously the way in which most fiduciary operators who wanted to administer deceased estates who did not qualify as one of those trust companies in operation on 27 October 1967, how they got around this, because you can just nominate yourself, or in your client's will, you can have your the natural person, the person him or herself nominated in the will, and as we shall later see, that has consequences. And then you can have alternative nominations should that person not be available to take that. So Regulation 910 was a horrible little piece of legislation, of subordinate legislation. To my mind, it does not exist anymore. I don't think it was saved by Section 119 of the Legal Practice Act. But you may find some masters office sporadically saying, well, are you entitled to administer deceased estates under Regulation 910? We hope there will be a change. There was a change to Section 103 of the Administration of Estates Act 3 years ago, I think, which gives the Minister of Justice under the Administration of Estates Act the power to promulgate regulations about who may administer deceased estates and fees and so on and so on. We haven't seen any draft regulations yet. And we are going to discuss Section 14 of the Administration of Estates Act a little bit later, and then I'll say a little bit more about that. I see it's 15:01, so let's take another 5-minute break. Let's make it 5 minutes now. Let's be back at 7 minutes past 3. Thank you.
Okay, sounds good to me.
Okay, I see it is time to carry on. I've had two questions. Would Regulation 910 exclude the ability of surviving spouses to be appointed as executors? No. Under paragraph 4 of Regulation 910, the surviving spouse is one of the exceptions. I just didn't put that on the slide. Can a CA registered with SICA be an executor? That is how that paragraph 3 of Regulation 910 was always interpreted. I will deal with, I will come back to the question who can be an executor in a moment when we talk about section 14 of the Administration of Estates Act. Okay, right. So reporting an estate. Section 7(1) of the Administration of Estates Act says that the death must be reported within 14 days to the Master's Office of the area where the deceased resided. This reporting must be done by the surviving spouse, or if there was no surviving spouse, the closest family member. Obviously, if the person didn't have any family left, then anybody who knows about the death would then be required to report the estate to the master's office in 14 days, within 14 days of death. As a practical matter, a lot of deaths are reported after the 14 days, and there is no real consequences of reporting it late. Obviously, the executor, if there is a professionally appointed executor, most of the time in practice will report the death. Then Section 8 requires anybody who holds a will of the deceased to hand it in at the Master's Office. Section 8(1) requires that. And then destroying or hiding a will of a deceased is a crime and carries a maximum penalty of 7 years imprisonment. That's Section 102 of the Administration of Estates Act. One can imagine that there are sometimes reasons for a family member or a disgruntled family member to want to destroy a will, but it is a serious offence, and as you can see from the penalty clause there. Personally, I had a couple of such situations over my career where people who were not heirs wanted to know why they were not heirs, etc., etc. And it can become quite interesting at times and quite tense at times. The master must register each document lodged with the master's office. The Act says it must enter it into a register so that there is a record that document was lodged with the master's office. At the moment, it is quite a challenge. Some master's offices refuse to physically accept the document. You have to throw the document in a box in the entrance foyer of the master's office due to COVID. I was in fact in a meeting this morning where certain commitments were made by the Office of the Chief Master around giving proof to executors that they in fact did hand in the original will with the Master's Office. You can imagine the problems that could arise if such an original will gets lost, goes missing, and the person who handed it in at the master's office has no proof of that. The protocol now is that you are, as an executor, entitled to take a letter, a receipt, acknowledgement of receipt letter with the will, describing the will, and the master's office is obliged to date stamp that letter, which you can then take a copy of, which you can then take with you after you've handed in the will to serve as proof that the will was actually handed in at the master's office. Following minimum documents must be handed in when the estate is reported. Completed death notice, there is a specific form, the form J294. Original or the certified copy of the death certificate, original or certified copy of marriage certificate or acceptable proof of marriage, declaration of marriage by the surviving spouse indicating the marital regime, all original wills and codicils or documents purporting to be such, the completed inventory, form J243, we'll get to that now, showing all the assets of the deceased, completed acceptance of trust as executor, another form J190, certified copy of the photo page of the executor's ID document. All these documents are available at that address, at the master's web pages on the Department of Justice and Constitutional Development's website. What I don't see on this list, and this list comes straight from the website, is original certified copy of the ID of the deceased. It's good practice for an executor to actually take in the ID for processes with the Department of Home Affairs. I have a question. Will the master accept the original certified copy of a will? No. The master will not, because the master, in terms of the Administration of Estates Act, the master is not allowed to receive a copy of a will without a court order. So no, yeah, the original has to go. Either the only original or a copy original, as I said earlier. I know of several businesses who, as a matter of normal standard practice, do several up to 3 copy originals and get all 3 of them signed. Yeah, I see a comment. I dropped the original will and the documents on 27 March 2020. They can't find the documents. What can I do? I would suggest, if you haven't done that already, contact Mr. Edric Pasco, who is the master in Durban and Pietermaritzburg. He's in charge of both those offices. But after that, the chances are you will have to bring an application to court to accept a copy. I would obviously, if I were in your shoes, I would ask for costs against the master who lost the original. All right. Reporting the estate, the inventory must be supplied to the master by the surviving spouse or nearest family member under Section 9. Again, the executor usually does that for the family if it's a professional executor. The inventory must contain all the known assets at the time. The inventory must include assets of the deceased if married out of community of property, assets of the joint estate or estates if married in community of property. If the deceased had more than one spouse and were married to all of them in community of property, then obviously all of those estates, the assets must be included in the inventory. Details of persons present when the inventory was made must be supplied. So if it's always a good idea to have more than one person present. So you have to supply the details of whoever was present with you when you compiled the inventory to supply to the master's office. Letters of executorship are issued in Section 14 of the Administration of Estates Act. The executor can be nominated in the will, but can be appointed only by the master. So an executor is not appointed by a will. Executor is appointed by the master. Executor can at most be nominated in the will. As long as the nominated executor is not incapacitated, Section 14 actually says that the master shall appoint the nominated executor. So it then becomes the master must just check whether the executor, the nominated executor, is for any reason incapacitated. One such reason would be if the person has been estate's been sequestrated in the meantime and the person is an unrehabilitated insolvent. Then obviously, if you're insolvent, you can't be placed in that position of trust where you're going to deal with the assets of a deceased person. Appointment is made by issuing of letters of executorship. The master under Section 14 may demand security, may require security for the administration of the estate. The purpose of security is obviously to ensure that should something go wrong and assets are lost, that the loss can be made good. Now, security, practically, security comes in the form of a bond of security. There are a number of short-term insurers in South Africa and specialist insurers doing that kind of insurance, issuing bonds of security. It's also known as court bonds. So the master may require that security. The executor cannot do any administration without the letters of executorship. And what's made it worse in the last number of years is the increase in fraud. Earlier this year, there was an elaborate fraud scheme where the part of a syndicate got forged death certificates, went to the master, reported the death of somebody who is still alive with a forged will, got letters of executorship, and then cleared out the bank account of an elderly person who was still alive. Fortunately, they were caught, as far as I know. I don't know what happened in that matter further, but the problem that we currently experience is that the master's offices, some master's offices, are fairly far behind the curve, and it sometimes takes weeks and months to get letters of executorship. In the meantime, the executor cannot exercise any of the powers, unfortunately, that's the situation we're sitting with. I have a couple of questions. One is the antenuptial contract required to be submitted to the master? The master may obviously ask for that. I would hesitate to give them the original of the antenuptial contract. But obviously, if there is doubt about how the parties have been married, the master could ask for that as proof of what the executor states in the preamble to the liquidation distribution account about the marital regime applicable. Next question is, if a person dies in Mpumalanga but the master's office Joburg is closer than Bombela, will the master accept that Johannesburg is in the area, or does it relate to the province? I think you will find that the especially the master in Joburg, is not keen on accepting jurisdiction that does not really belong there. But in any part of Mpumalanga, as far as I know, will fall under the High Court in Mbombela, and therefore the master in Mbombela will be the relevant master's office. I'm not aware. There may be practical arrangements, but I don't know. But strictly speaking, according to the Act, it will have to be the seat of the master in whose area of jurisdiction the death occurred, or where the person actually stayed, not where the death occurred. I've been asked, another question, I've been asked to assist an administrator appointed by power of attorney by the executor to help wind up an estate. What sort of document would be required between the administrator and me to use for reporting to banks, etc.? You will, if you are assisting the administrator, you will need both the letters of executorship, certified copy of the letters of executorship, and an appointment, basically a power of attorney from the executor to you before the banks will touch you. Obviously, the banks are extremely jittery about people wanting to get access to bank accounts of deceased people for very obvious reasons. So you would need certified copy of the letters of executorship, and then a power of attorney from whoever is the appointed executor in the letters of executorship. Right, finding and taking control of assets. The executor must take control of all assets once in receipt of letters of executorship, and this is why the delay in issuing letters of executorship is so serious, because there may be loss of assets before the letters of executorship have been issued. The executor may leave assets under the control of the person who claims to have a right to retain control under a contract, retention, or attachment. Obviously, some assets, especially in cases where the surviving spouse is the major heir in a will, a lot of the physical assets will be left under the control of the surviving spouse, but the executor has to take charge of the bank accounts and open a deceased estate's bank account, as we will see soon. The executor may release funds for subsistence of the deceased's household. That's also all under Section 26. And obviously, the amount that you release as an executor for the subsistence of the deceased household will depend on how much there is in the estate and what kind of standard of living the surviving spouse or other members of the household had been used to prior to the death of the deceased. The executor can obtain a search warrant on suspicion that somebody is hiding assets. So executor has serious powers. So you can go to obtain a search warrant from the master if you suspect that someone is hiding estate assets. You can go and search for them. That search warrant must be executed as if you're looking for stolen property, and the person executing the warrant must hand any property of the deceased found during the search to the executor. So quite serious powers there. Obviously, to prevent a situation where assets are hidden. Okay, so the next step under Section 29, the executor must place an advertisement in the Government Gazette and a newspaper circulating in the area where the deceased lived. And this advertisement must call for creditors to lodge claims against the estate. Now, in practice, this advertisement is often referred to as an advertisement for debtors and creditors, but the Act actually doesn't talk about debtors, but it has become practice to call on debtors to come forward in that ad as well. Yeah, I'm not sure all debtors are going to come forward living voluntarily to say that they owed deceased money. It's usually a case of the executor must go and find those debtors by going through the documents and records of the deceased to find out who was owing money to the deceased. That advertisement must run for at least 30 days from placement of the advertisement. The Act prescribes the information that must be in the advertisement, but the Act does not require that the advertisements must be on the same day. Now, it's become practice to advertise in the newspaper on a Friday because the government gazette comes out on a Friday. The legal notices gazette comes out on a Friday. So it's been practiced to advertise on the same Friday in the government gazette and in the newspaper that is in circulation. However, we have recently found out, because it's becoming more difficult to comply with this because of print newspapers closing down and stopping the issue. A case in point is the Media 24 paper Volksblad in the Free State and Northern Cape. Had its last print edition on the 8th of August. Since then, it's since the 10th of August, Monday the 10th of August, it appears only as a digital publication. And in place of that, Media 24 said we have a number of community-based papers, but they appear weekly, and some of them appear on a Monday and some on a Thursday, etc., etc., etc. And there's a new directive was issued by the Office of the Chief Master very recently to say that the Act actually doesn't require that the ads must be on the same day, and that the 30 days will run from the date. The 30 days will, the period of advertisement will run from the date of the placement of the first advertisement, but the 30 days will, but the period will expire 30 days after the date of the last of the two publications. So that's just a common sense approach to deal with that. See, we have a number of questions. I've been asked to assist an administrator appointed by power of attorney. Okay, no. I've dealt with that one. There was another one. When requesting a duplicate motor vehicle registration certificate, if lost by the deceased, does this have to be done in the area where the deceased resided, or can it be done in Johannesburg even though the deceased resided in Pretoria? That depends on where you live in the country. In a place like Port Elizabeth, as far as I know, there's only one place where you can get that duplicate motor vehicle registration certificate. In the Western Cape, where I live, you can basically do it at any of the municipal service points. You don't even have to go to Department of Transport office or another licensing office. There are licensing office in any municipal service point where you can get it. You will have to find out where in the area that you're dealing with, how they deal with that. Another question is, if there is no living person in the household after death, what costs, for example, rent repairs, are payable and for how long? That will depend on the contract that the deceased had, and it will depend on the landlord if you talk rent and things like that. remember, in principle, the executor steps into the shoes of the deceased, and has to wind up the deceased's affairs. I would think that your rent would at least be payable until the end of the month. And we get to claims against the estate in a while, and I will come back to this, but in the end, it is for the executor to decide which claims are valid claims. Okay. Another question: deceased nominated and appointed her son, failing him her daughter, failing her Nedbank as executor. Neither son nor daughter want to be an executor, nor do they want Nedbank to be executor. They have asked if I will be the executor. Can the son and daughter do this? And any reason why Master will not accept them nominating and appointing me for the appointment as executor? The short answer is no. Unless Nedbank also indicate that they are not interested in taking up the appointment. If Nedbank does take up the appointment, then and Nedbank's been nominated in the will, then the Master, according to Section 14, shall appoint Nedbank as executor. The son and daughter, unfortunately, has no say in this unless they take up the appointment and assume you as executor, if the will includes the power of assumption. If not, then they won't have any say. If there is a power of assumption in the will, they can take up the appointment, assume you as executor, and then resign the executorship and leave you. But that still leaves Nedbank in the equation. So you will first, they or you will first have to request Nedbank not to take up the appointment. What happens if the executor is the landlord of the household, therefore has a vested interest? Well, then you have a conflict of interest. and you will have to deal with that conflict in an appropriate way. What that appropriate way will be will depend on the circumstances. I would think that whoever is that executor, should have thought about that and should have avoided that situation, because it can become quite untenable. Okay, claims for and against the estate. Property in an estate may not be sold in execution before the expiry of the period to lodge claims. In other words, before that 30-day period has expired, property in the estate may not be sold in execution. After the expiry, it may not be sold without the consent of the master for amounts below 5,000 Rand. Or property with a value below 5,000 Rand. Above 5,000 Rand, you can only sell in execution with the consent of the court. So any creditor who wants to sell something in execution while the estate's under administration after the expiry of the advertisement period will have to apply to the High Court for this sale in execution. Executor must receive all claims against the estate and accept or reject each one. And that comes in with that comes back to that question about the which question was it? Sorry, I'm suffering from a senior moment here. I think it was the. Oh yes, yeah. The claim. Let's say the claim for rent, etc., etc. The executor must accept or reject each claim received against the estate. Obviously, if he rejects the claim, the creditor can then object to the liquidation and distribution account, but we'll get there. The executor must collect all claims in favor of the estate. It is not, let's say in the case of an accrual marriage, let's say where the accrual claim goes in favor of the deceased. The executor doesn't have a choice but to enforce that claim. Now, that obviously doesn't mean that the surviving spouse must pay the claim. It will depend on how much the surviving spouse inherits from the deceased estate. If that is more than the amount of the claim, then obviously the surviving spouse and the executor can apply set-off. But the executor cannot just decide not to enforce the claim, because it's the executor's duty to collect all claims in favor of the estate. Section 28 says that the executor must open a current bank account as soon as she or he holds more than 1,000 Rand of estate funds, and may open a savings or investment account. Until a couple of years ago, that 1,000 Rand was 100 Rand, but it's been increased to 1,000 Rand. The executor may convene a hearing before the master or a magistrate to obtain evidence about disputed claims. So if there are disputed claims, the executor may, under Section 32, convene a hearing before the master or before a magistrate to obtain evidence about the disputed claims. The opening of the bank account brings into play a question that I received yesterday about the payment of interest on a savings account or on an investment account in which some of the funds have been placed. And the question goes along the lines, can the executor keep the interest or must it be credited to the estate? And the obvious answer is that interest belongs to the estate. In fact, between 10 and 15 years ago, still, 10 years ago, it was still a practice amongst the big trust companies to run umbrella accounts. And it's still a practice today. I mean, many executors run something like Nedbank Corporate Saver or Investec has got a platform. Grindrod Bank has got a platform. There are other banks who have such platforms where you have an umbrella account, a bank account into which all deposits can be made, and then sub-accounts for each deceased estate. And that pooling of money obviously can draw higher interest than what an individual account would be able to earn at a bank. And until about 10 years ago, it was general practice amongst the big operators to cream off some of that excess, so that the estate is in a better position, but that the executor also get part of the spoils for actually running the banking, the back office banking on behalf of the estates, instead of just opening individual bank accounts. An end was made to that by a Chief Master's Directive, I think 4 of 2011. I've got it here on the other screen. I just want to see if I can quickly get it open. Yes, Chief Master's Directive 4 of 2011, paragraph 3.1 reads, the instance where the executive failed to credit the total interest earned on Section 28(1)(c) investments plus any administrative fee paid as a result of the investments amounts to breach of the executive's fiduciary duty. All income must be specified under the income and expenditure account. The executor is only entitled to the prescribed fees, and there is no legal or statutory basis upon which an executor can claim a portion of interest earned by the investment. So that is what Chief Masters Directive 4 of 2011 says. You can find that on the Masters web pages on the Department of Justice website. There is a heading for Chief Masters Directives, and you can find all the Chief Masters Directives there. Let's see whether there's something else here. Okay, I've dealt with that one. Due to COVID delays, obtaining letters of executorship is taking a long time. Can executor take certain steps in the meantime, such as advertising for creditors? Will bank furnish bank balances, other steps, etc.? The short answer is mostly no. You cannot advertise for creditors until you have received your letters of executorship. The banks will not touch you without letters of executorship. You will not get anything from them without that. Another question, what sort of recourse is there if an executor took the interest from an estate savings account rather than distribute to beneficiaries, specifically because the Act does not say it must legally go to beneficiaries? Well, the recourse is the Chief Master said you are in breach of your fiduciary duty. So if you have issue with that, you will have to take that Chief Master's directive on review to the High Court, and I don't have much hope that the High Court will find in your favor. The point is that the Act may not say that the interest belongs to the or that the interest must go to the beneficiaries, but the executor is in a position of trust and has a fiduciary duty to act in the best interest of the beneficiaries, of the estate and of the heirs, and therefore it's quite logical that the heirs and the beneficiaries must get the benefit of interest on capital that belongs to the deceased estate. Another question, if there are two executors, does the acceptance of claims need to be approved by both, and what happens if there is a disagreement with regard to landlord, executor, so on? In principle, if there are two executors, it's only yes, they have to both sign everything, unless one of them gives a power of attorney to the other. And you find that practically in cases where the surviving spouse and somebody else, some professional person, is nominated in the will as joint executors and also appointed by the master. The surviving spouse many times then just give a general power of attorney to the professional executor to run everything, and the executor, the professional executor, can then act without the other executor under that power of attorney. What happens if there is a disagreement? Well, then that disagreement has to be settled in some way or another, if need be, by going to court. Obviously, if the one executor is not happy with what the other one is doing, that executor may object to the liquidation and distribution account. Okay, I think I've dealt with all the questions for the moment. All right, done with this one. Claims for and against the estate. After the advertisement period, the executor must determine the solvency of the estate under Section 34. If insolvent, the executor must notify all creditors owed more than 1,000 Rand and request the creditors to, within a period not less than 14 days, indicate whether they wish the estate to be handed over to be dealt with under the Insolvency Act of 1936. If they give no such indication, or the majority of the creditors decide not to go for that option, the executor carries on under the Estates Act, the Administration of Estates Act. The executor will then liquidate all assets, pay all creditors, take his fee, distribute anything left amongst the heirs and legatees, although the only circumstances under which there could be anything left for the heirs and legatees would be if there's been a sudden increase in the value of one of the assets or some of the assets after the executor already started the process to deal with the estate as an insolvent one. Liquidation and distribution account. In a solvent estate, the executor must submit the L&D within 6 months after receiving his letters of executorship. The master may extend this time. The format of the L&D is prescribed in the regulations published in 1972 under section 103 of the Act. That's paragraph 5 of Government Notice Regulation 473, published in Government Gazette 3425, 24 March 1972. L&D can be a first and final account, or there can be more than one account. The most I ever saw was 9 liquidation distribution accounts. When the assets are found after the account was submitted, when assets are found, then you can lodge supplementary accounts. Account must include a heading that must state the number of the account, in other words, first, second, third, whatever, full names, date of birth, ID number, marital status, and marital regime of the deceased, whether it's a massed estate, and the master's reference number. There must be a money column. There must be a subheading called liquidation account, and the liquidation account sets out what all the assets are. There must be a subheading recapitulation statement, which basically adds up all the cash. There must be a subheading distribution account, which says what happens to all the assets of the deceased. How is it going to be distributed? What is the executor going to do with it? A subheading income and expenditure account showing what income has come in to the account, into the deceased estate after death. A subheading fiduciary assets account, a subheading estate duty addendum, and a certificate by the executor confirming that everything is accurate and the truth, etc., etc. So that's the structure of the liquidation distribution account. After the executor drafted the account, the master must examine the account, and the master may request vouchers, may say, well, where do you get this? And show me where you paid the hospital or whatever. Once the master is satisfied, the account must lie open for inspection at the master and the magistrate's office for 21 days, at least 21 days. The executor must advertise in a newspaper and the Government Gazette again that the account is open for inspection. And again, the same applies. It doesn't have to be on the same day, but the 21 days will expire after the date of the later of the 2 advertisements. Any interest party can submit an objection to the master. If the account is free of objections, the executor can distribute in accordance with the L&D account and take his fee. The master must refer all objections to the executor, who must respond within 14 days. So if the master receives an objection, it must be referred to the executor. The master must consider the objection and the executor's response, because the executor must then respond to the objection and say, why, oops, sorry, I made a mistake, or no, I don't agree with the objection for the following reasons. The master must then reject the objection or instruct the executor to change the L&D account. Anyone who is dissatisfied with the master's decision may approach the court on application to set the decision aside. And if the objection is rejected, the executor distributes the estate. So if the account was free of objections, or if the executor, or if the objection is rejected, the executor can immediately carry on to distribute the estate. I have been reminded about the question about probate. I just want to get it. Is probate always required to close a bank account in the UK? And if so, does it take away South African executors' right of control and administration of funds in SA? Well, no, because the letters of executorship given by the master, obviously, the master doesn't have jurisdiction outside South Africa. So what happens in practice is sometimes banks overseas will be happy to deal with a South African executor, depending on what is going to happen with the bank balance there. If it's going to another person in the UK, there shouldn't be any problem. But I mean, there's nothing that prevents the bank from saying, hang on a sec, I'm not going to deal with you unless you get a grant of probate in the UK under resealed letters of executorship, which basically means that the master in South Africa recertifies that the letters of executorship are actually correct, and that is then sent with a master certified copy of the will to the overseas institution, or in this case the UK, and you then apply for a grant of probate on that basis in the UK. There are businesses, international businesses, that basically deal with this. There are at least 3 that I'm aware of that that could assist with actually handling things on the other side. But obviously, if the amount of money is not substantial, then chances are the bank overseas will be happy to work with you without the bank in the UK may be happy to work with you without a grant of probate. Okay, let's carry on. Taking fees and other administrative costs and other administration costs, as the executor's fee is just another claim against the estate. It should not be taken before the account is free from objections and all other creditors are paid. In fact, in the Fiduciary Institute, we are quite strict on our members around that. We recently had a disciplinary matter where a complaint was received against an executor who took the fees prematurely before the account has lain free from objection. Fees regulated in the regulations to a maximum of 3.5% of the gross estate value. Professional fees for property valuations, transfer costs of immovable property, or income tax and other compliance services are claims against the estate. So the executor doesn't have to pay that from his fee. The executor is entitled to other general administration costs as allowed for in the Chief Master's directives. In practice, it's known as postages and petties, although the postage is not sometimes not doesn't feature anymore, but small extra charges that needs to get paid. There is an allowance for that in the Chief Master's directives. The executor is entitled to an income collection fee of 6% of such income collected. In other words, if you collect 100 Rand on behalf of of the estate, you are entitled as executor to take a fee of R6 on that. Income tax, including CGT. Obviously, the deceased is liable for income tax, including CGT, from the beginning of the tax year to the date of death. So SARS doesn't leave you alone in the last couple of months of your life. The deceased estate, since the 1st of March 2016, the deceased estate is a separate taxpayer and is liable for income tax from date of death. From date of death until the date of distribution of the assets. That's Section 25 of the Income Tax Act. Executor is the representative taxpayer for both the deceased last income tax as well, income tax return, as well as for the estate. For how many returns would be necessary depending on how long the estate takes to administer. Cost of compliance with the Income Tax Act is a claim against the estate. It's advisable for the executor, I think, to obtain specialist services for this if appropriate. If it's a normal site situation or pay-as-you-earn situation, and there isn't much to the return, then the executor can do it him or herself. If it becomes complicated, it should be done. The executor should really get expert advice, if not an expert. I mean, if you're a tax expert and a tax practitioner in any event, then there's nothing preventing you as executor from doing that. Distribution of the estate entails paying all creditors, including service providers, to the estate, tax liabilities. Okay, before I go there, I got a question yesterday about the tax around the rebates. Deceased estate pays income tax on the natural person table. All natural persons, deceased estates, insolvent estates, and special trusts pay income tax on the natural person tax table. They don't pay, for instance, the trust flat rate. But the deceased estate is not entitled. A deceased estate and an insolvent estate is not, and the special trust is not entitled to the primary rebate under Section 6 of the Income Tax Act. So the funny anomaly there is that the deceased estate does qualify for capital gains tax purposes for the 40,000 annual exclusion. So the estate does qualify for that exclusion, but does not qualify for the annual income tax rebate, the normal primary rebate that every natural person qualifies for. I've got a question. Okay, I see I've got a couple of questions there. Can I just deal with the distribution of the estate quickly, and then I'll get back to the questions. The distribution of the estate entails paying all the creditors, including service providers, to the estate, tax liabilities, etc., giving instructions for the transfer of immovable property, transferring investments like listed shares, collective investment scheme units, and the like to legatees and heirs, selling assets to generate cash if necessary, paying out cash to legatees and heirs, and that's it. That's the distribution. I've got two questions. After the L&D has lain free of objection at the Magistrates Court and advertised on Government Gazette and newspaper, can the executor start distributing without master's authority first, or must wait for the authority from the master? The Act, some masters say you can't do anything until I say so. but they are actually not supported by the Act. The Act says if the master confirms that there was no objection to the L&D account, then the executor forthwith distributes the estate. Is the wording in the Act. So what some masters' officers do is they will ask you for vouchers and all kinds of other things and delay. But strictly speaking, they cannot stop you if it is confirmed that there were no objections to the account. The master can't stop you from advertising, from distributing. Sorry. Right, then there's a question: how do you claim against on L&D account at the master? I'm not quite sure I follow what that is about. Let's deal with estate duty, because one of the earlier questions was about the valuation of assets, and that has a bearing on estate duty as well. Under the Estate Duty Act, the executor is also the representative taxpayer for the payment of estate duty. Duty may be recovered from certain parties, for instance, beneficiaries under insurance policies. There's a formula for calculating how much can be recovered in Section 13 of the Act. But be that as it may, the executor is liable towards the master for the payment of estate duty, and must then recover whatever can be recovered from other parties. If the duty is not paid within 12 months from the date of death, interest at 6% per annum will be charged on the outstanding amount. And under Section 10, the Commissioner may give an extension of this period if he's satisfied that the delay was not caused by the executor or another person liable for the duty. Okay, that's the end, and I'll allow general questions, but I just need to respond to this question. What value do you use in the L&D for things like shares? CGT is deemed value at date of death. Yeah, that's the market value for CGT purposes. Is this the same value you use in the L&D, or do you put what you received when sold? Okay. All assets in your L&D account should be at market value at the day of death, with the exception of bona fide agricultural land, where for estate duty purposes, the value used is the market value minus 30%. But for L&D purposes, everything should be at market value. The deceased is deemed to have disposed of all his assets to the deceased estate on date of death, and it is market value at date of death which will be the disposal value, and the capital gain for the deceased would be market value as a date of death minus base cost, excluding, of course, everything that goes to the surviving spouse, because that's a rollover under Section 9, capital H, capital A of the Income Tax Act. If the executor sells anything during the course of the administration of the estate, there is a difference again between L&D and estate duty. For estate duty, there is a difference between L&D and tax purposes. For L&D purposes, you deal with market value as at date of death. For tax purposes, you will work with the value realized in the sale in the process of administration of the estate. Because remember now, For the estate as a separate taxpayer, the base cost for capital gains tax would be the date of death value, and the market value, the disposal value will be the price realized in the sale. So there can be a gain or a loss. Shares for L&D purposes is easy. You just check what the share price, the closing price was on the day of death, and multiply that by the number of shares, and you have your L&D value. And again, if you sell them in the process of the administration of the estate, there could be a capital gain or income depending on whether the deceased was a trader in shares and didn't hold the shares for their capital value. You have to distinguish between values for tax purposes and values for L&D purposes, because for L&D purposes, it's value at the date of death. If you transfer an asset to an heir without selling it, then that date of death value forms for capital gains tax the base cost for that heir. And if the heir then later disposes of the article, then the capital gain will be the difference between the date of death value and the disposal value on the date of disposal, the market value on the date of disposal. I hope that answers that question. All right, that's it then. And we are at the end of the presentation and questions. Any further questions? You are also, Danny, I take it if somebody wants to unmute and ask a question live, is that possible?
I'm sure Danny can do that.
Yeah, there is. So if anyone has like and wants to talk and speak their question instead of typing it out, they can. They just need to somehow, there's a raise your hand function, and that allows me to know. Okay, I see 2 people raising hands. Let me see who's raising hands. Let's go allowed to talk. Okay, and George,
Hi,
you got a question?
George, yes, I have. Just a very quick one. If we sell or we dispose of assets, of share assets, because it was not enough to finance the estate's cash obligations to creditors, etc., but
yeah,
they are sold at a loss versus what was the value at the time of death, are these losses a claim against the estate, or you cannot deduct?
Those losses will come into the estate as the separate taxpayer. It will come into the estate's tax return as a capital loss. I assume it's capital, not a situation where the deceased was a share trader, because then it may be income, or will probably be income.
Not a trader, yeah.
Yeah, so then it will be a capital loss and will be taken into the calculation to determine aggregate capital gains. Obviously, if the loss is more, if you sit in a net loss situation at the end, then unfortunately that loss dies with the estate. When the estate is finalized, it can't be transferred to an heir. But a loss can be carried forward from one year to another, just as with a natural person taxpayer. You can carry your capital losses forward into a next year for capital gains tax purposes. For the estate, but once the estate is finalized, if there is still then a net loss situation, tough luck. It dies with that estate when the estate is finalized.
So there's no capital gains as such if there was a loss. It's just that you cannot use it as a claim against the estate for estate duty purposes.
No, because it is not the estate as separate taxpayer that pays estate duty. It is the deceased as at date of death.
Okay.
To a large extent, unfortunately, they've complicated matters with this fiction that they created, that the deceased estate is a separate taxpayer, because an estate is actually just a conduit from the deceased to the heirs. But yeah, and any capital gains previously, before the 1st of March 2016, any capital gain or capital loss would, after date of death, would basically accrue to the heir who eventually receives the assets, or to whom those assets would have been awarded. But they've complicated matters now, and so if there is a net capital gain situation in the estate, obviously the estate will pay that capital gains tax. That capital gain will be included in the taxable income of the estate for that year of assessment. But it will not be a claim for capital gains tax purposes. No, because the estate, sorry, for estate duty purposes, because the estate duty is for the deceased as at date of death. And then certain costs are allowed, certain after-death costs are allowed. But capital gains tax are only allowed the deceased's capital gains tax as the liability stands as a date of death.
Okay, so basically, if share portfolio is transferred to beneficiaries as a share portfolio, there's no talk about capital gains there. The capital gains does not come in. It only comes in when you sell, when you have to sell.
It only comes in if you. It only comes in if you sell in the process of administering the estate.
Yes, for whatever reason, whether you're wanting to finance the obligations or for whatever.
Yes, yeah. Which speaks to the necessity to, in planning, make sure that there is sufficient cash in the estate, because you don't want to start selling assets that may actually create a capital gains tax liability in the estate.
No, of course. But of course, now in this times of COVID, when you have something like that, you may find that the value of the estate, the share value at the time of death versus if you have to sell now, the shares have dropped, then there is no issue there because the value of those shares have dropped.
Yeah, or what you could have had is the person died end of March, and the shares have recovered spectacularly since then.
Then you have the other problem. Yes, of course.
Then you have the other problem. Then you have a capital gains tax. Then you have a capital gain problem.
And it's aggregated, because if you share 5, 6, 7 shares, the overall value, whether it was a gain or loss, is what's taken into account.
Okay. Because capital gains tax is always for that year of assessment. You calculate the aggregate gain.
Yes,
gain. And then remember, the estate has that 40,000 per annum that the estate is under administration, that 40,000 exclusion for capital gains tax.
Is it good practice to, when the beneficiaries inherit not the exactly same proportion? So if you've got, let's say, 2 beneficiaries, but the one beneficiary gains a lot more according to the will or not, the cost obligation, can they be prorated to the beneficiaries' individual inheritances, or do you still have to, or is it still divided by 2?
No, if you sell, I hope I understand this correctly. If you sell assets in order to generate cash for the estate, for the cash needs in the estate, then anything that is left accrues to the residue. So whoever inherits the residue will then inherit whatever is left. If you sit in a situation where shares have been specifically bequeathed, left as a legacy to certain heirs or certain legatees, then if there isn't sufficient cash in the estate and there's nothing in the residue that you can sell, then what you have to do is you have to do abatement of legacies. You have to reduce proportionately reduce legacies in order to generate the cash.
Yes, we have the example where a specific asset was bequeathed to one of the beneficiaries, not to all. So, for example, if the estate value was 100, the one beneficiary has a benefit for 75% of that, the other one has 25%. That means the costs of the estate should be proportionally distributed to per the amounts that they have benefited. Is that correct?
Sorry, I hear you saying that if you are you talking now about where you abate legacies?
Yes. So, for example, if one beneficiary has 75% has got 75% of the benefit as per the will, and the other one has 25%.
Yes.
If you have a cost of 20, you also will proportion those costs accordingly.
Yes. If you start abating legacies, then you do it on a pro rata basis. Yes.
Yes. Okay. Thank you.
Yeah.
That's me done.
Sorry, I see somebody says, sorry, you did not answer my question. Anonymous attendee. I don't know which question that was. And then there's one question. Can a CA registered with SAICA be an executor, or must you be registered with IRBA to do this? At the moment, to my mind, anybody can be an executor because of my view, Regulation 910 doesn't exist anymore. If anybody argues that 910 still exists, the general practice was that CAs registered with SAICA were accepted as being exempt from the prohibition in 910. In other words, yes, you can do it. I've got a question. What happens in the case of a company? Not sure I understand.
He follows up his question at the end. What's the procedure to replace a director who's passed on? How do you appoint a new director? I think.
Well, that's a matter for the company to sort out. Whoever now becomes the shareholders, if the deceased shareholder or if the deceased director was also the 100% shareholder, then the executor is now the 100% representative shareholder, and then the executor will have to appoint a new director, or keep on acting on behalf of the company, which be tricky. I had a colleague 17, 18 years ago, a woman who had to run a vegetable farm for about 9 months, which became quite tricky. So it really depends on the situation in the company. I mean, the internal operation of the company and the memorandum of incorporation will determine how directors are appointed, and so on, and it depends who holds the shares in the company. Somebody else said, should the capital gain in an estate not be 300,000, not 40,000? No. You have to distinguish between the deceased as a taxpayer and the deceased estate as a taxpayer. Since the 1st of March 2016, the deceased estate itself is a separate taxpayer from date of death to date of finalization of the estate. The 300,000 is for the deceased in the year of death, in that last tax return from beginning of the tax year to the date of death. There's a 300,000 exclusion for capital gains tax. In the deceased estate, anything that happens after date of death in the administration process of the estate, any capital gains tax that arises there is the normal 40,000 annual exclusion for a natural person is available for the estate as taxpayer. Okay, I'm a bit worried about the one who says I didn't answer the question. I don't know who that was. Okay. Stan, I see you active online. Do we have to pull the plug?
I'm trying to see if we can wrap it up. If there's anybody,
Yes.
just a few notes for people listening and those who've registered. If you can just wait a couple of days, your certificates will be on your way as long as you've paid. And if you haven't paid, please do so. The notes, if you don't have notes, or you should have received the notes by now, but if you don't have them, please would you send an email. You've got the address either for Danny or myself, and we'll send you the notes straight away. And just want to thank you, Louis, for a very interesting talk, a very interesting, of course, a morbid subject, but I suppose one that has to be dealt with. And yes, thank you very much. And thanks to everyone for coming on and attending the Zoom or Zoominar or webinar, whatever you call it today. And I just want to wish everybody well and safe. And from me personally, good night. And from everyone else, I don't know, Louis, if you want to take more questions, that's up to you.
I don't see any new ones.
I just see one last one about a beneficiary. If the beneficiary is asset of a NPO public
capital gains tax payable. Yeah. Because remember, the capital gains tax there won't be any capital gains tax in the estate, but the capital gains tax will be for the deceased. Because remember, he doesn't dispose of the asset to the PBO. He disposes of the asset for capital gains tax purposes to the deceased estate. The deceased is deemed to have disposed of the asset to his deceased estate on date of death. So there will be capital gains tax if the asset is then transferred in the administration process to the PBO, NPO. That obviously, as with all other transfers directly to an heir, will not generate any capital gain in the estate as the separate taxpayer.
So we've got a couple of PBOs and NPOs that will gratefully accept this and save you a lot of tax if you want to. Anybody wants to put us in your will.
Yeah, obviously a bequest to a PBO or an NPO is a deduction for estate duty. So you get that benefit. The deceased gets that benefit
right.
Out of such a bequest. Okay, that's it.
Thanks. Okay, thanks very much. You want to leave the meeting? We're going to close off now. Thanks very much. As I say, need notes or anything like that, please send an email. If you need, your certificate will be sent out in the next couple of days. Thank you.
Okay, the one last question I see is what's if estate is less than 125,000?
Oh yes, yeah. Estates of it's not 125 anymore. It's 250 since about 5 odd years ago. So if the estate is under 250,000, it is a so-called 18.3 estate. It resorts under Section 18 sub 3 of the Administration of Estates Act, and no executor needs to be appointed. It can the master just appoints a master's representative, who is usually a family member, to then close bank accounts, do the necessary, and distribute to the heirs according to the will or according to the rules of intestate succession.
All right, yeah. Thank you again, Louis. That was great. I'm just going to end it now. I think everyone's, unless sure. Last call for questions, or I think we're done.
No, I think so.
Yeah. Cheers, everyone.
Looks like it.